So this client of mine, he's an older guy, professional, been working in the same field for over 3 decades. He's almost retired, and the day after this incident, he was scheduled to go on a vacation with his wife. Well, his wife had asked him, "Honey, can you go pick me up some food?" And of course he obliged. Goes to his favorite local restaurant, sits at the bar, and has a couple drinks while he's waiting for his food. Gets the food, is on his way home. As he's driving, what he does not know is that sitting stationary are officers from the Johns Creek Police Department, and they are conducting speed enforcement using a laser device. Well, they pick him up going about 72 in a 45, and they start following him. Now, these are Johns Creek police officers. Their authority is only within Johns Creek. And when they follow him, they don't turn their blue lights on until he is in the city of Duluth, where they have no authority to conduct any type of a traffic stop. So the blue lights come on, client pulls over, they are squarely within Gwinnett County, outside of Fulton County jurisdiction. The police investigate him, they ask him questions, and they make observations that are inconsistent with each other, being the two officers. First officer says, "Yeah, I detect slurred speech," and he had trouble handing over his driver's license. The second officer makes no mention ever in his report about slurred speech, and he doesn't observe anything about the license. Importantly, the second officer, the one who really conducts the investigation, never detects my client to have any odor of alcohol ever coming off of his breath, which was useful information for later negotiations. Ultimately, they decide to charge my client with DUI. He agrees to a breath test at the police station, the result being a 0.20, much higher than the legal limit. But when he submitted to the breath test, he only provided one sufficient sample. And the law says that in order for a breath test to be admissible, there has to be 2 sequential samples. I presented this information to a prosecutor just short of our motion to suppress hearing, and that prosecutor agreed that that breath test result would not be admissible. And we had our motions hearing, and I made other legal arguments. The judge denied all of those issues, yet that breath test was still not admissible at trial. So perhaps a year goes by, and we finally get scheduled for a trial date. A new prosecutor is on the case, and it came down to the wire where I was ready, and the prosecutor, she agreed with me about my contentions of the case, but she didn't have the authority to necessarily dismiss it or reduce it. She had to go to a supervisor, and as you have it, 9:00 p.m. Sunday, right before trial, I get the text. We can go ahead and resolve this case. My client, as soon as I got that text, I called him right away, and he was jumping up and down, excited on the phone. A great success.